objections, I take it, to what the Federal Circuit has said. One is that you think objectively baseless is too low, correct?
Yes.
You also don't think bad faith is necessary.
Agreed.
And do you also believe that litigation misconduct taken in conjunction with a case that is, let's say, of little merit but perhaps not as low as the standard that you have, that you're suggesting would justify an award of fees?
Yes, we believe litigation misconduct, especially in consideration with the weak case on the merit, makes for a strong candidate for exception.
Well, now, let's say I'm a district judge someplace, and I rarely get a patent case. How am I supposed to determine whether the case is exceptional if the standard is take everything into account, litigation misconduct, the strength of the case, any indication of bad faith, and decide whether it's exceptional? Exceptional compared to what? I have very little basis for comparison. How do I do that?
So I do not think it's a numerical comparison. I think when we're talking about an uncommon case, it's what would we expect of a reasonable litigant. So in the normal course, a plaintiff develops a product, they bring it to market, they get a patent, they're successful. A defendant recognizes the success, they look at the patent, and they try to design around, and a reasonable dispute ensues. So that's a normal case. What we're saying to a district court judge, the guidance we would give them is that this litigant, this plaintiff, acted in unreasonable ways, and district court judges are called on every single day to make those determinations.
Compared to what? Compared to the types of cases that the district court hears on a more regular basis?
District
or
courts
compared
handle
to patent cases?
I think all cases. Complex litigation requires litigants to act reasonably in procedural aspects and on the merits. I think
this is
no matter what other factors exist, it has to be objectively unreasonable. I mean, even if it is clear from other factors that this is a shakedown, a big company trying to suppress a little company, even if it's clear that there has been outrageous litigation abuse, misconduct by attorneys.
It is an important point.
All of those things cannot justify shifting the award unless it is objectively unreasonable.
No, Justice Scalia, that's not our position. Our position is if the only factor is a objectively unreasonable argument, that in appropriate circumstances that can be sufficient. We believe very, very strongly that if there are other factors present, that would only strengthen the case for
I've read enough cases in this area to be able to approach it as a district court judge who's not expert. I patent the following. For a computer, enter somebody's name, ask phone number, and they'll give you the phone number if you put in the right city. That puts some lists in the computer. They can patent that? Well, you add a couple of things, and you're going to have an argument that they can patent it, okay? Because it'll be very abstract language. It'll be able to patent almost anything. No, you can't finally, but objectively baseless. The patent attorneys are very brilliant at figuring out just how to do this. So we're never going to have attorney's fees in a suit if that's your standard. Well, but you could couple that with just barely over the line. What line? This vague line, no one knows what it is. In addition, all they did was say, we don't want to go to court and cost you $2 million. Please send us a check for $1,000. We'll license it for you. They do that to 40,000 people, and when somebody challenges it and goes to court, it costs them about $2 million because every discovery in sight. Okay? You see where I'm going?
Yes.
And so I do not see why you couldn't have an exceptional case where attorney's fees should be shifted. But if I'm honest about it, I cannot say it's objectively baseless. I can just say it's pretty close to whatever that line is, which I can't describe, and look at all this other stuff. Are you going to say that I can't shift?
I think the problem with the approach you propose there, Justice Breyer, is you're trying to deal with a very small slice of the problem of litigation. what you've described.
No, but of course, it may be a small slice of litigation, but it is a slice that costs a lot of people a lot of money.
But the problem,
and so I would like to know, if I do run across that small slice, why cannot I, the district judge, say, I've seen all these things. Taken together, they spell serious injustice, and therefore I'm shifting the fees. Okay? Why can I not do that, even though, as I just said and repeat, I cannot in honesty say it's frivolous given the standards for patenting that seem to be administered?
Because when Congress enacted the statute, adopted the exceptional case standard, it meant essentially to require that the litigation be unjustified and vexatious. Unjustified means that it is baseless. That's the understanding that existed all along. It has to have — it's not that it has zero merit, but it has to have enough merit to be to satisfy the standards of probable.